Start right at the top. The first section covers recommendations 1 through 4. So I will just open up the discussion and see if there are any comments, concerns about 1 through 4. I have a quiet group today.
Nadine, do you mind
Yes,
if I
Kent.
ask a
Yes,
question?
absolutely.
The one thing I wondered on this part is whether it was clear enough that referring to assessing online processes kind of generally, and then some of the laundry list that comes later, refer to, as I think the intention is, only to matters concerning agency adjudication, as opposed to any kind of agency decision. I note the title of the document is about agency adjudication, but I wondered if throughout it needed somewhere, maybe at the beginning or throughout, to limit this merely to the adjudicatory context.
Matt, did you have any response on that? You're muted.
One of the reasons why the report and not so much the report, but the recommendation is a little vague on that is it's never quite clear when adjudication starts in this sort of thing. If you're collecting a lot of information, say for a Social Security application, is that necessarily an adjudicative process at that stage? And yet it's still this, you would use the same technology to accomplish that goal, if that makes sense.
Kent, did you have any specific language in mind or just a general sense that we could weave that in? Or
no, and that was much to my disappointment. If you see my piece of paper, it's marked up in lots of ways and then crossed out, and I don't like any suggestion I had in particular, but it took me about 2 reads to realize, oh, this really is intended, I think, to be limited to it. So I don't, unfortunately, but maybe others didn't have that same issue that I did.
No, I think if it's something that came to your mind, it may well arise on others' minds. So I think it's definitely something, Matt, maybe we can take back and maybe just put in a comment that it's something we could look at and consider building in or clarifying in some way.
Nadine?
Yes, Russell.
I had somewhat the same concern Kent did, and I can't itemize them here, but there's a variety of references to the public, which leads you to wonder whether or not it's the public as filers or just the interested public who may want access to something. And as we go through the text, we may want to flag that because I found it a bit confusing in a few spots.
I think that's a good point. There were some spots where we use users, we say users, which may be the people who are registered, right, to use the system as opposed to members of the public. I mean, the first recommendation speaks about members of the public. And whether we mean they're members of the public or users. I'm trying to think of another terminology.
Especially
Russell.
because it says are made publicly available, and you begin to wonder what that means. Like, is it just a website that John Q. Public or Jane Q. Public can go to and get stuff or not?
Mm-hmm. I mean, the word stakeholders comes to mind, but that's a broad group as well. Renee, did you have a thought? No? Okay. What was your sense, Matt, in terms of the agencies? Were they thinking broader in terms of anyone being able to access, or just those?
Generally speaking, you would register for one of these processes if you are going to be engaged in the adjudicative process, either as a representative, a staff member in a representative's firm, or a party yourself. Where I think some agencies do allow members of the public to view publicly available case files and submit into them if they want to. You don't Not every agency requires registration.
So we can't say registered users. Matt,
Just, I guess, apropos of Kent's question and Matt's response, namely, what do you do about, for instance, Social Security, where you have an initial stage and application stage? Is that an adjudicatory stage? I don't know, Matt. What about agencies? Are any agencies using these processes at the investigative stage to receive documents at that stage, or is that entirely outside the scope of the project?
Well, some are using them for the receipt of complaints about something that would then be investigated. But I think you could argue that filing of a complaint might be the first stage in an adjudicative process.
So if I were asked, I mean, but this could potentially encompass an agency situation where, I don't know, take the CFPB, which has a fairly formal investigative process. The CFPB serves, requests documents from me or so forth or information. I might be using one of these online processes to submit those documents.
Correct.
so this first recommendation, Matt Gluth, I know we got our two Matts, is meant to be in the broadest sense to cover all of those possibilities, right?
I think it was intended more to sort of, I think we weren't quite thinking as broadly or as fundamentally as this discussion is reflecting, and it was more intended to suggest that if you're going to create an online process for users to submit evidence, submit data into the adjudicative system, that you should design it to work with your own electronic case management system and with any other website processes that you have set up that the agency uses internally.
Kent?
I wonder if one way of trying to resolve this is, Nadine, like you said earlier, number 2 refers to users. If paragraph 1 also referred, to processes, I hate used by users, but the users partake in, and you go through that laundry list, and then in paragraph 3, it's clarified that, as he says here, the online self-help portal should be designated to allow different functionality with appropriate permissions for different types of users, and indicating in that paragraph there are different types of users depending on the information, its sensitivity, the process at issue, and the nature of the agency decision-making process.
So you're thinking maybe users would work in one. What if we said accessed by?
Yeah, I like that.
Since that's the title of this section. Any other thoughts on this? Dan?
Could I make a small suggestion to change any to work effectively with the relevant electronic case management systems, simply because there are so many ECMSs, and I don't think what we're calling for here is interoperability across, many different ECMS systems.
I think that's helpful. Yes, thank you.
Could I ask one other sort of just
Yes,
clarification question, Matt?
absolutely, sure.
Matt, I thought the report was really great, but actually, the other Matt's question actually raised this for me, which is, what do you do with like in these kinds of complaint situations where, for instance, EPA has a tip portal that members of the public can submit tips. But then there's internal routing that can both go into like the civil adjudicative or enforcement or even criminal enforcement side. Like, I guess this is, I guess I'm just wondering here how broadly we're scoping here. You know, are we thinking about adjudication that excludes certain kinds of enforcement actions, or are we intending to include something like the EPA tip line?
I think my sense is that obviously the boundaries of what adjudication are kind of fuzzy. And that's a great example of it. I would probably lean toward not including something like that because it's not necessarily the onset of anything, whereas a complaint that leads into an investigation with the CFPB would be, or an application for benefits is the beginning of an adjudicative stage. Whereas a tip, it could be anything, right? And I'm not sure whether an online tip form is significantly different from sending an email to a tip email alert. I don't know. But you know, I think like you point out, there's a lot of sort of stuff at the edges of this that we may either want to keep vague or we might need to solidify depending on how the discussion goes. Thanks, Dan.
Thanks.
Matt, Committee on Style, I guess we'll need to, I think system may need to be with A relevant, or system needs to be plural. With relevant.
Got it.
Yeah.
Thanks.
Or it needs to be A. Yeah, I don't think A works. Okay. Anything further on 1? So we'll go to 2, where we're talking now about online self-help portals. So that's a little shift, right? From online processes. The portal, I guess, Matt, is one type of process. Is that fair?
You know, the report kind of builds it out that way, mainly because the report also deals with electronic filing by email.
Right. Okay.
Which then does not have a portal. So it's sort of, that's the way the report was structured. But here,
Okay.
generally, since we're talking about building out these processes, portal is being used, I think, in a broad sense to incorporate like something that would only allow electronic case filing or electronic filing, but also allow for some of these other things, accessing virtual appointments, scheduling meetings, that sort of thing.
Okay. So we got a good list here. Does anybody have any thoughts about how the list is presented? Should it be added to? I thought it was a good list. Kent.
Just one question that I had was the item G about scheduling meeting, conferences, hearing, and other appointments. I went back and forth of whether I thought that was a good idea, especially as a should that's stated in the actual question, as opposed to consider developing this or not. I can imagine situations where an ALJ or a certain hearing officer doesn't really want to put this up, and it would take quite a bit of management to always update it and know when there's an opening on something, and it may just be easier working through the administrative assistants to do it. So I really thought maybe the way to cure that is agencies should consider developing this laundry list and figure out what works for them.
Russell.
Does the as applicable in line 6 take care of that?
Maybe I read as applicable to mean does it apply, as opposed to you want to do it or not, but I understand the point.
This is Roxanne.
Yes, hi,
What if it said
Roxanne.
hello. What if it said as applicable or feasible?
Kent, any reaction to that?
I like it.
Yeah. Okay. Russell?
Fine.
Thank you, Roxanne. I think that was a good point, Ken. I missed that one, that there needs to be a little more flexibility there, perhaps. Jack, welcome. Unmute. Yeah, good.
One of my little wordsmithing things. I would make the or an and. Because I think we say it has to be both applicable and feasible. If it's only one or the other, it's not what we mean, right?
Good point.
Thank you, Jack.
That's
We
one of
count
my
on you for this stuff. Thanks, Jack. Okay. Anything else on the list? Russell,
Well, just a small point. It's not on the screen now. It's item J.
Yep.
Only if they can rely, I think that they is the agencies, but it might not hurt to make it clear. I had to read it twice to be sure it wasn't users. But only if the agency can reliably predict. I think that's what it means.
okay. I think, is that line 19 on the screen?
19 now, yes.
Yep. Yep. No, that's very helpful. Thank you. I like that too. Anything further on the list? Three and four, let's start with three. So we're still talking about the portals. I think this is the helpful language that Kent pointed out, where we're kind of explaining the types of users that we're envisioning here. Kent.
I'll stop talking soon enough, I promise.
No,
But I've got one other small thing I would add here since we changed it to users. I do think there are times when it is useful for the public to access things like journalists that may want docket entries and orders that have been issued. So I think I would omit the and before amici curiae and then do and the public. Or and the public generally.
Any reaction to that, Russell?
No, not on that one particularly.
Okay, Roxanne.
Yeah, one other user that we have that frequently uses our online e-filing system is court reporters. Because when we hold hearings, the way that we have the court reporters give us the transcript is we have a special function for them in our e-filing system for them to upload the transcripts into the e-filing system. So I don't know if you need the word court reporters or if you want to do just something like more generic, because I'm sure there's other people out there that agencies might want to allow that we haven't expressly listed. So I don't know if you want to just like say, in addition to saying and the public generally, and I don't know if there's something more generic we could say.
Jack.
Yeah, when you're talking about court reporters, you're talking about agency employees or the staff of people of representative, because it also already says they're staff.
They are not employed by the agency, but we
Right.
contract with them
Okay,
to
so contract.
transcribe our hearings.
Well, yeah, but it's agency contractors, right? Including, yeah, and then the other, I'm not sure exactly about that, but I don't understand what the word generally is doing at the end there, as opposed to just the public. What's the difference between the public generally and just the public? I don't know.
Roxanne, how do you feel about contractors?
Yeah, that's fine. I just wanted to throw out there that there might be other individuals beyond those that we've listed.
I would have to go back through my notes, but I believe there's also medical experts at VA and SSA that also provide direct access through these kinds of tools for their medical reports.
Any other thoughts?
Well, or, maybe we don't need contractors. It just seems so, I'm sorry. I'm just talking without being called on. Sorry about that.
It's totally fine.
So contractors just seems a little clunky to me because it might not be meaningful if people don't know what we're talking about. So maybe we just say, instead of just take out contractors, but say different types of users, including but not limited to, and then have our list. Individual agencies will be able to figure out what they need or don't need if it's beyond this list.
And what they can accomplish realistically. Okay, Jack, did you have a follow-up on this?
Yeah. Why not just add a phrase, agency, staff, and contractors? At the beginning, agency, staff, and contractors, because, you know, it'd be nice. I mean, the agency, there's a lot of different people in the agency that might need to have a look at it, you know, or use it for some reason, including the doctors you were talking about with medical reports. So, yeah. And I think staff of representatives takes care of anyone in a similar situation with regard to, you know, representatives. So.
I think that works. Anything further on 3? Russell, was yours on 3?
Yeah, it was.
Okay, great. Go
Line
ahead.
23, I would delete be designed to, partly for aesthetics, but also you don't want to leave the inference that the agencies are going to do all the designing. They may be buying these things. But I don't think you need the words anyway.
Anything on that? I think that makes sense. Okay. 4. We're still talking about self-help portals. Monica?
So on this one, you know, user privacy can be implicated by both like the registration information that a user is putting in, but also very much by the submissions themselves. And looking at the context of the second sentence there, it looked like we were talking mostly about the registration information, because I think if we're talking about the submissions themselves, we probably aren't saying enough about that in number 4. And I also know there's another section in the back that talks about, you know, managing sensitive documents. So I'm just wondering if our focus on number 4 really is that registration information, like the address that you're putting in there when you register, your phone number, your email, et cetera, that we should spell that out a little bit more in 4 to make it clear what we mean.
What if we said something to protect the privacy of user registration information or something like that? Is that
Yeah,
really what? Yeah,
that's what I was thinking about, but that's only appropriate if that is in fact what we
All
were
this is
going
about.
for in number 4. Yeah.
Yeah. Matt, did you have any reaction in terms of what this was meant to
I think
target?
number 4 was was designed to ensure that you are the person that you claim to be when you log in, so that, you know, to protect your account from being stolen and used by somebody else.
Mm.
So with that in mind, is that the addition of that language is at work for that purpose? I mean, I think it does. I mean, that to me looks like it's getting more at, you know, identity protection rather than whether you have, you know, specific confidential information in the filing itself, which should be covered by something else.
Right, like you said, Annika, that's covered down below in the section on filing, or at least that's the way it's intended. The committee will decide whether it succeeds.
Renee?
So wait a minute. So is privacy really the right word in 4 if it's that security concern? Because I mean, you know, privacy has all kinds of different meanings, but the explanations seem to be about, you know, that protecting the the integrity and the authenticity of, the system, and not so much about user privacy. It could be privacy as well, but maybe we need to expand that or have a definition of privacy that includes this authentication concern.
I think that's a good point. Jack, did you have a response to that?
I was just going to suggest a phrase, something like ensure the integrity of the system. But I think that authenticate users might be helpful just to stress that one particular point, but then and ensure the integrity of the system, something like that.
Roxanne, did you have language here? Oh, you're muted.
I was thinking we might not have to use the term privacy, which Jack just suggested taking out. I was just thinking we could say mechanisms in place to protect user registration information. But if we're taking all of that out,
Yeah.
we could say information and authenticate users to ensure.
I like
Oh,
that.
yeah, I was thinking it would be in place to protect user registration information, comma, and to authenticate users to ensure the integrity of the system, or yeah, I don't know how I feel about that now, but anyway.
I think we're getting closer. These are all great points. Any other thoughts on this? We can drill down here. Kent.
Just a minor one, channeling Jack here. I think I'd get rid of in place and just say they have security mechanisms to protect, and continuing on.
Can I just say that then you want to change the to that?
That's better. We got rid of a 2. We had too many 2s. Roxanne, does that? Oh, you're muted. Sorry.
Sorry, I've got the mute over on one screen and the document on another. So no, that looks good.
And I want to go back to Renee and Annika if this was a concern raised initially. Does this get to the point that you had concerns about?
That works for me.
Great. Great. Thank you for raising it.
Likewise.
Great. Anything further on this one? Roxanne? Nope. Oh, yep.
Yes. Are we, in the next sentence, are we committed to recommending? Well, I mean, I guess we're saying if you're going to have people register, you should have them use something like login.gov. Do we want to recommend anything about agencies considering allowing users to use these portals without registering? And the reason I say that is because at my agency, we spent a lot of time thinking about, are we going to make people register in order to e-file and do other things? And we ultimately decided, because we have a lot of people who may not have legal representatives helping them, that to make the system easier, people can log in if they want to. It saves them time because they don't have to fill in all their contact information, et cetera. They can see all the cases they're on, et cetera, et cetera. But we make it like if you want to shop online as a guest, we do it like that so that people can still go in and e-file without going through any sort of login process. I don't know if that's something that we would want to recommend that agencies consider, to the extent that that would be helpful for their constituents.
Renee?
I would be in favor of that because I think it is so annoying to have to register on all these websites just to do like one transaction. And so I think that's good. Also, if you think about, back to, who might be the members of the public who want to get access to some things, it might be, like a journalist or something like that. And they don't want to be like, registering all these websites and having people know that they're looking into something necessarily. I mean, I think they would own it if they were asked about it, but I just think it seems to be a little problematic.
Matt Gluth, did you have any thoughts on this aspect?
I also am very supportive of allowing access without registration because it would have made my job a lot easier trying to poke around and learn about these things. But I think Roxanne, your agency was, I think, the one I was thinking of why there's agencies that require users, because I think yours is the only one that didn't. But there might have been one other. Registration is very common. And I think you can see why in the long run, because if you're going to engage in an extended adjudication, then you need to protect your privacy. You need to protect the privacy of the information you supply, that sort of thing. But maybe for initial actions such as filing a complaint or filing an application, maybe you're not sure where it's going to go. Maybe you don't want to have to log in at that stage. So I think we could consider adding a sentence here or a separate recommendation that agencies should decide whether to require registration.
I was thinking it would be a separate, but Roxanne, I'll let you spin that out.
Oh, yeah, sure. I think a separate sentence, and it'd be along the lines of, if appropriate, agencies should consider allowing users
To access
the portal without registration. And if there's a better way to phrase that, please feel free.
Renee, did you have any further?
Yeah, and
No,
for us,
okay.
we have a lot of individual charging parties who they only may come in contact with us once, because they're filing something to start, and we just didn't want people to, because when we switched to requiring e-filing, we just had a lot of concern that we would be causing problems for people who couldn't or didn't want to have to register.
Any thoughts on this new line? We can leave committee on style and Matt to, oh, Kent, good. Yeah, anything.
I like the idea. The only thing I'm debating is whether we need the additional sentence, because as it reads, it says agencies that require. If agencies allow both options, then they're not requiring that one register for the login, if I understand it correctly. So I wonder if it's already allowing this exception in the language.
You're really targeting the agencies, agencies that are either starting from scratch or agencies that require users should consider maybe not requiring users. Roxanne, did you have?
Yeah, I totally see what you're saying, Kent. But it may be a little too subtle if the idea is to recommend that people actually just give this some thought, because it could be that their agencies, especially if Matt, in trying to do this, was running into a lot of agencies that required logins. I don't know how many of them stop to think, do we have to require logins every single time? And are there people who use our website who would benefit from not having to log in? I just don't know if people have gone through that thought process.
I take that point. I wonder if moving the sentence that you've proposed before agencies that require makes that a little smoother. We don't think you should require it necessarily, but if you do, here's an option that you should provide.
You read my mind, Kent. Anything further on this? Okay. Yeah, we might need to wordsmith that a little bit now.
I'm a little
Oh.
worried about it jumping from security to non-registration back to security issues. So
Mhm.
we might need to reorganize it or something. I could.
Maybe the security needs to come last. Jack,
Yeah, I feel, I'm not aware of any portals like this where you're allowed to access it without
registering.
registration if it's about someone's particular case. I mean, I suppose when I go onto the Massachusetts court situation system, I don't think I have to register to get court documents. So maybe that's what we're thinking about. But I think if we're going to say something like this, it needs to be in something brought out in terms of the public's right to know in a way that makes it clear that we're not sort of undercutting exactly what we said in the sentence before about security. That, you know, not making sort of public documents easily accessible, you know, is what that's about. Where, you know, whereas the first part is about sensitive information and material that you would only want the users to be able to access. So I think, you know, you maybe need to break out something, number 5, about, you know, facilitating public access to documents that are appropriately made available to the public. I don't know, Matt, what do you think about that, Matthew? Is that consistent with what you're trying to do here?
I think we're less concerned with making sure that the public has access to public documents. ACUS has other recommendations that do that. This is more about reducing burdens in accessing adjudicative systems.
So maybe it's maybe you add a clause to that first sentence without compromising the public's ability to access public documents or something like that.
Dan, did you have
Yeah,
suggestion?
this is, I think, related to Jack's comment, because I think part of what trips me up here a little bit is the term self-help portal, which could either be a portal for you to just access resources to be able to navigate an agency process. But in paragraph 2, it seems to really contemplate a whole lot of case-specific, you know, protected information that really should be, you know, subject to you know, some form of authentication. So I think that's what's tripping me up here a little bit, why there are these dual purposes here of like some folks who think about the self-help portal as just access to general information, whereas here we're really using it in a very specific way to navigate the kind of case the member or the user facing case management system. So we could consider either changing the term self-help portal, but I like Jack's addition. The other thing that just occurs to me, I guess I'm curious, Roxanne, to hear from you, like the other thing that's very much happening in a lot of these spaces is that just as we saw with FCC's notice and comment rulemaking, right, where we had tens of millions of bot-generated comments, the general response within sort of cybersecurity is to require forms of authentication to really guard the agency from getting a whole lot of like bot-generated content that could degrade the integrity of what's available on these portals. So I guess that's the other dimension I would add here. I wouldn't want, if appropriate, agencies should consider allowing us to nudge them in favor of doing that when it could lead to sort of a degradation of the integrity of information that's spelled out in paragraph 2.
Yeah, I can see that happening in rulemaking, but for us, it's our e-filing portal that we allow people to e-file without necessarily logging in or using a password or anything. What it means that they don't log in and use a password is it just means they need to type in their contact information before they upload their document or documents. Can't tell you how many times we've had people call us in a panic because their due date was today and they can't figure out how to log in, and we just say, you don't have to log in, just upload the documents, and then they're so relieved. So it's working well for us, but what you're talking about sounds more like something that would happen with our rulemaking, but we do that through regulations.gov, so we don't have to worry about that.
Now, it's really interesting, Roxanne. I know with our system, we're like, I guess, most agencies where you need to be a registered user. And I think there's been concerns about, we don't allow kind of the public to just access our system. It's only for parties. So maybe that's kind of the parameters that we're focused on. I've heard some people say, well, could be, what if they're posing as a part, they're just a journalist. We don't even know, they're getting into our system without being authorized.
Yeah, and it's not really getting these people into any system. They're just e-filing documents. And I think it was stemmed from us having a lot of angst about switching to requiring e-filing. And because we have a lot of users who are not all that sophisticated or don't have the help with it. And so basically that was the compromise we came up with, which was that people do not have to register or use a password or anything to e-file. And we've never had a problem with people. I mean, basically they have to put in a case number. They have to, select what kind of document they're filing, and then they file a document. And we have had people file oddball things at times, but it's still on the right case. They were just like, why did they file a photocopy of their ATM card? We don't need that. But that's not because they were some bot or something. That was just somebody not understanding what they should have been submitting.
That's really helpful, Roxanne. Would you not, would it not be, I guess I would actually consider if you're putting in information like the case number and sufficient identifying information, that could actually be considered a form of authentication, because you're like authenticating that you are actually a party to this particular case. It's obviously not the same as having like a registered user account, but you're engaged in a form of authentication.
Yeah, they can't just randomly e-file something not related to a particular case. And so they do have to enter that minimal information.
I'll point out quickly that recommendation 3 identifies the general public as one potential user and says that the system should allow different functionality with appropriate permissions for different types of users. So we may already address this to some degree.
Sure, and I was just raising it as something for people to think about.
So I guess,
oh,
yeah, go ahead, Dan, please.
So would the following work, if appropriate, agencies should consider allowing users to authenticate to the portal without necessarily without a registration or something along those lines. Because I think you do want, like the NLRB example is a great one, right? But you do want some level of authentication.
Any reaction to that?
Sounds good to me.
Jack? You're muted.
Yeah, I actually think the first sentence kind of takes care of that. If you look at it, it doesn't say that that they should have, that agencies, self-help portals should have registration requirements, right? It just says they should have security mechanisms that protect user registration information. That's assuming there is registration, and authenticate users to ensure the integrity of the system. That just says that, and so that's the same thing as, it doesn't say there that in order to authenticate, you have to have been registered. So maybe we're making something out of nothing here. And that it already because we haven't really said anything explicitly like you should require everyone to register. Or authenticate users to ensure the integrity of the system, whether users are required to, I don't know. I'm not sure, less may be more here. I'm not
Roxanne,
sure.
how-
Other
how-
people
how-
feel that it's important to add that. That's fine by me. It just seems like it's already in there.
I think it's the fact that the first sentence assumes that there is registration information. So I suppose, less ink would be spilled if we said that protect user registration information where required, comma, and authenticate users, and then you could cut the next sentence.
How about this? How about take the word registration out?
Just user information.
And take out and authenticate users
That's more elegant.
and just take out the where required. then,
Where
too.
required, you wouldn't need that, yeah.
How does that
And are
work?
you saying also take out and authenticate users? So
No.
just say,
No.
okay. So then you can take out that next sentence. Is that the idea?
Yeah. Because we haven't really suggested that anyone have to register. I mean, if an agency wants to have people register, we're not saying not to.
Roxanne, do you think that language covers kind of the situation?
Well, yeah, I mean, I don't feel super strongly about it. I was only trying to make the pitch that agencies should think about the fact that they've probably got some agencies have people who aren't going to know how to navigate a complex portal, make it easy for them. And I just wanted to make that explicit, but really I don't, this is not a hill for me to die on. I'm not that concerned about it. It works for us.
Any other thoughts here? Okay. We'll move on. Electronic filing and forms. I think the one question that we had here on this first one, so agencies should permit all parties and require. So permit and require. So permit all parties, but then require represented parties. Any thoughts about what this should say and if that's kind of the right note we want to hit here? Roxanne.
Okay, so since you have the exception that says, except where it's impossible or impracticable, if you have that, do you really need to say should permit all parties and require all representative parties? Why not require everyone if you're giving them that out?
Matt Gluth, any reaction to that in terms of what you found?
Yeah, so that was crafted directly because that seemed to be the most common system that agencies were setting up, that it would be okay for pro se parties or others to use it, but if you were represented, the representative was usually required to use it, and so we phrased it that way. But in crafting it, we sort of discussed internally whether, even though agencies weren't really necessarily doing this yet, whether it would be better for ACUS to be slightly ahead of the game and recommend that electronic filing be the default for everyone, unless they opted out.
Yeah, basically from our agency, we require everyone to e-file all documents in all cases, unless they have a reason, can state good cause for why they can't do it, which is pretty much what it says after you've edited it.
May I just ask a question, Roxanne? How does a filer or a member of the public communicate their need to file by paper?
All they have, what we say in our rules is that they have to provide a statement saying that we have some language that I can't remember off the top of my head, that they have to file a statement saying that they cannot use the filing system for whatever reason. And so in that paper filing that they would give us, They just have to have some sort of statement in it. I'm providing this in paper because I don't have the means to e-file or something like that. So that's what we would accept. Surprisingly, we really run into very, very little of that. But that's what we put in place so that we could continue to receive hard copies from people who couldn't e-file.
And do they mail them, snail mail, or do they email them?
Yeah, I think it varies. It's mostly with our regional offices, but snail mail is the main way, or they come directly into the regional office. I don't know of any hard copy filings that we get at the board level in DC. All of it comes in by e-filing. In fact, I think it's very, very little at this point that we get. We've been requiring e-filing, I think, since 2017. And so I think at this point, we're getting almost no paper filings, but mail or in person.
Any reaction to this? Monica?
So at our agency, we are in the, we strongly encourage e-filing, but we permit paper filing. But I think, like Roxanne said, like, well, probably like 98%, if not more, of our filings are actually coming in as e-filing. And that was, I think we were pretty close to that even before the pandemic, and then post-pandemic even went up a bit more. But in the, I wonder whether, given the diversity of agencies and the kind of adjudication that they have, whether something that, AIC is coming out suggesting that agencies should take the step of requiring it when, based on the report, it's not clear to me that, the majority of agencies are doing that today. And it doesn't take into account, like the particular population that the agency might serve, or, the socioeconomic issues, like all kinds of things could really impact whether a particular agency's stakeholders who need to file things really should have to jump through an additional hurdle. So I do have some concern about, actually going so far as to recommend that agencies require this. But I definitely think they should consider it, right? I mean, this should be a discussion at the agency. They should be taking into account what kind of filers they have, what kind of hurdles there might be, and should look into this issue pretty carefully. But I worry a little bit that this might look more like a one-size-fits-all approach.
What about something that kind of goes back to the language that was there, which would be, should permit parties to file documents electronically and consider requiring parties to file documents electronically except in, so it would be somewhat what was there before, but the consider would be in there. Roxanne?
Yeah, I was just gonna say, so for Annika, does the exception not cover that, where it says where it's impossible, or it could say just even impractical or good cause? Does the exception not give enough leeway for agencies to think through what works for us or what doesn't?
Well, I think that the way it read before, at least the way I interpreted it, is it permits parties to do this, so we should definitely encourage it, and that the exception was geared more toward those represented parties who would otherwise be required to do so, except in certain circumstances. So, and maybe there was a little bit of agreement problems in that sentence as a whole, because we both had both permit and require, and we had the exception. So maybe that was a problem to begin with. So
I see. So you were seeing the exception as maybe just applying to the requirement, not to since permit was in there. Okay.
Right. I didn't think that you needed an exception when it's not a requirement.
True.
And the exception only covered represented parties as written. So if you were pro se, you had the option.
That's how I read it.
Yeah. Any thoughts? I mean, I think the gist of the report and what we're trying to get at here is we want agencies to allow this mechanism. And then in some circumstances, they may want to require it.
I like this phrasing better.
Any other thoughts? Jack?
Yeah, what would, I know it's a little awkward, but saving some words, would it work to say agencies should permit and consider requiring parties to file documents electronically? I don't think you need the word all. In any case. You have a comma, we put a comma after requiring? Yeah, commas, I think commas around that
Commas.
clause.
Yeah.
I don't know, what do people think about that?
Does this need to be rewritten at all? The except, the qualifying
That'd be
clause
separate.
except to apply only to requiring or also permitting? Because I'm not sure it reads right the way it reads
Yeah, you're right.
right now. I'd also strike in instances, that's a small point.
Russell, do you have a fix?
No, I think it does need to be rewritten. Just, I should note also, whatever this is, recommendation 22 has to be revised in light of it, but do you have to spell out somehow, I mean, going back to Roxanne's point, somehow to identify, rather than have it ad hoc, what somebody who doesn't want to file electronically or can't file electronically has to do? What kind of showing they have to make, or is there some form that has to be used, or is it just you leave it to their own devices? I don't want to file electronically, and here's how I can go about persuading you I don't have to. I mean,
If
this
we
is
end
a
the-
way of saying, I just think the thing perhaps needs to be taken back and thought through again. It's pretty complicated the way it is right now.
Well, if we end the first sentence, if we end the sentence after file documents electronically, period, and then deal with if agencies require parties, implement some mechanism that would allow, and maybe that's where you flesh out the how circumstances of getting the exception from the requirement.
Right.
I think there's some good language here, but maybe it's, as you're saying, there's an opportunity to sort of explain how you would go about doing that. Matt, does that address your concern? I think you were worried about the placement of the clause. Matt?
Yes, it does. It's precisely, yes.
Okay. Roxanne?
Perhaps for this new second sentence, we could say if parties require, if agencies require e-filing, get rid of parties, require electronic filing. Agents, if they require electronic filing, implement exceptions. Just take out the mechanism, all the rest of that, to the point where it says to the when. And maybe when becomes where or whatever, but implement exceptions where electronic filing would be impossible or impractical, or a party has good cause for needing alternative submission. I think that being a little more vague here would be good, because it might be a mechanism like Matt Wiener was asking me about, which is how do they convey to us that they can't e-file? That's one thing, but that also needs to cover the situation where an agency might say, okay, well, we can't require e-filing of videos because our system can't handle it. And that happens to be our case. So if we could have this sentence cover both of those scenarios where either the party can't e-file because they just can't do it, or the agency can't allow that e-filing because it just doesn't work for them. I'm just wondering if we can have the second sentence be broad enough to cover all of those scenarios.
That's an excellent point, that it's not just about the party. It could be just the feasibility issue.
Yeah, we run into it a lot with evidence during investigations. There's certain types of evidence, like physical evidence or whatever, that can't be e-filed. So we have to figure out some other way to get it into the record. But that's our issue, not the filer's issue.
Jack?
Okay, I'm not sure that, I think my suggested change may be what's having us having all this trouble to rewrite the next part. So maybe, I don't know, what if people think we should go back to before the change about and consider requiring. But I think on the feasibility issue that was just discussed, you could just say when feasible at the end after the words electronically. Because, you know, if it's not feasible because the system doesn't take the file, then of course you can't require them or even permit them. I mean, you know, I suppose.
Any thoughts on that? Roxanne, does that?
Yeah,
Or do you-
I personally, if the second sentence is phrased the way it currently is, I don't think we need the when feasible, but certainly when feasible doesn't hurt.
Well, I do think the goal here is to cover both grounds, right? It's the party that can't do it and has a reason why. And it's the impracticality. And we want to be sure that if you require it, you're creating a system that allows for those exceptions. I think that captures this here. And is there any other language we need
punt
here?
to the committee on style.
Yeah. Okay. I'm game for that. See if they can smooth that out a little. Okay. 6. I was gonna suggest deleting all before users. I mean, I think it allow users, but that's just me. Jack, you have your hand up. Did you have? No. Okay. Russell.
In line B, it's just my ignorance. I don't know what file documents at significant size means. I don't understand what that says, and maybe
Matt?
I'm ignorant about it.
Sure. The intention there was to identify that, or was to direct agencies to consider how large, say, some measure of their filings are in file size, so megabytes, gigabytes, whatever, so that we don't run into the problem that some agencies have where they can't accept video. Video is commonly being submitted.
Roxanne.
Russell, would it make more sense if it said file documents of a significant size rather than at?
Well, significant suggests big. What you're really saying, don't file documents that are too big to be received. Is there some way to say that more elegantly? If that's what you're trying to say?
I thought it was trying to say, make sure that your agency should make sure that their document size limitations, whatever they might be, is large enough to allow people to file what's normally filed. So like if you have, you know,
If
right.
if it's clear to everybody but me, let's not worry about it. I just raised it because I didn't understand it, but that could be true of a lot of these things.
So is it trying to cover the situation, Matt, where the documents exceed? I like Annika's point about size limitations. So is there a way to build that in here? So we're trying to allow users to file documents that fit within or do not exceed. Yeah, I don't know how to capture that.
This
Roxanne.
makes sense. This makes sense to me because we're saying allowing users to file documents of large enough size to encompass common filings. That makes sense.
Russell?
If it's clear to anybody else, it's fine with me. I just raised it because I stumbled on it, that's all.
Matt, any other, I mean, in terms of the intention of this one?
Not that
Thoughts?
no, I don't think so.
Okay. Anything else on the list? Seven? So this is trying to cover, Matt, correct me if I'm wrong, that you could email these things.
Correct. Or using a Dropbox-like technology.
Uh-huh. Is that what file transfer protocol, another word for that, Dropbox?
Correct.
Okay, good to know. All right. Anything on 7? Ken?
Do we need the comma after electronically?
I don't think so. Okay. Dan?
A small technical thing. I mean, FTP is not secure as conventional, so I would say something like using a secure file transfer protocol, SFTP.
I like that. Thank you. Anything else on 7? You can move to 8. 7, 8 and 9 both assume the agency has a case management system. Oh, it's getting into a lot of tech speak for me, but 8, so web-based tools, which is great. We're talking about users, structured metadata. You know, you're speaking another language to me. Anybody have a reaction to 8? All right, go ahead, Ken.
This is probably out of ignorance, but I didn't understand why we would want them to have to input the metadata as opposed to the program pulling it. So what I'm thinking about is like when I save a PDF into Word, it knows it's a PDF. I don't necessarily have to enter in PDF on it or some other format that I may not even understand. That's the format it exists in. That strikes me as clunky to require the users to, maybe they have to.
Roxanne?
Yeah, I was tripping up on reading that a little bit, and then I realized how it applies in our real world scenario for our e-filing system. When someone puts in their case number and they say, I want to e-file something, what comes up is a list of documents that someone could e-file at that stage of the game. So in other words, depending on where the case is at in the system, in our agency, there are only certain types of documents somebody could file. Now, it can be a fairly long list, but there are limited types of documents. So we ask people to say, what type of document are you filing? And they just click on the one they're filing. Is it a motion? Is it a brief? Is it a whatever? They're identifying by clicking from our pre-selected list of what they can be filing. And that is super helpful for us, because then when the document comes in, it's pre-identified as a request for review of a decision in direction of election, or a brief in support of a motion for summary judgment, or whatever. They've selected what it is they're filing in language that makes sense to us. And then it's in our system properly identified. So I think that's what the metadata is. Not that somebody's like typing in metadata. It's that somehow the user is being prompted to tell us something about what they're filing. Is that what it's getting at?
That's exactly it.
So it's select or identify, those are the verbs we're looking at rather than input. Dan.
I think the kind of scenario that this recommendation is trying to get at is when SSA, I think, first built out its ECMS system, it wasn't capturing any metadata on the type of document, or there were versions of it. And that just makes things very clunky. It's essentially just like a file portal. But I think maybe one way to get to Kent, your concern is actually, you could use the phrasing, these tools should enable the capturing of metadata, such as document type. It really can just be, as you're going through the form, I'd like to file the complaint, and you're clicking on, or you're uploading it into the complaint field, or something like that. And it should capture that information without necessarily requiring additional user input when not necessary. One small thing just on the earlier 7, I would just change the parenthetical to SFTP, just to be clear that it's the secure file transfer.
Thank you. Kent, do you want to react to that? And then I'll go to Roxanne.
Yes, I appreciate both what Dan said and Roxanne. And Roxanne, I think what you identified for me is an ambiguity, and maybe I'm the only one reading it this way. I understood document type to mean the type of document, whether it's a PDF, a Word version, as was discussed earlier about when things should be a PDF. And I think you very helpfully indicated, no, we're talking like motion to dismiss or some kind of filing. I don't know that I have a good solution on how to fix that. An agency document type, adjudicatory document type. I'm not sure what the adjective is in front of it, but that was really useful.
Roxanne.
So I was in a meeting with a bunch of IT people when we were building our case management system, and the contractors were going through what they were planning to present about the latest update or whatever. And they said, and then we will put everything in English-like terms. And I just started laughing, and I was the only person who thought that was funny, because I'm like, well, can we just use English as opposed to English-like terms? But speaking of English-like terms, maybe if we can get away from saying metadata, unless that's important, but maybe we could say something like, with original language that allowing users to input structured metadata collected by the ECMS, maybe if we said something like, allow users to provide information collected by the ECMS, such as document type or whatever you want to say there. Would that get us where we need, or do we need to use the term like structured metadata?
I'm all in favor of getting rid of structured metadata, but it's what we replace it with. And is it provide or identify? I mean, if what we're really talking about here is that they're identifying what their document, what their filing is, which I think we had that language, Matt had that in there. at some
Sorry, can I
point.
react to that? Because I do think
Yes,
that
Dan.
part of the communication here actually is to the IT contractors who would be building out a system like this. And so I do think that
Fair.
having something like structured metadata is important, because the way this could be interpreted is that users have a free-form text field and they can identify what they're filing. And that is just a mess that no one wants to deal with. It's basically useless, because the reason why this metadata is really important is it allows you to build on top of that sort of quality assurance systems of the type that SSA built out. So I do think I would still favor something like structured metadata to just be clear to whoever is actually going to work on this ECMS system to build in that functionality.
Roxanne?
Okay, I have a suggestion. So what if we say, keep the language I had there just a second ago? So these tools should allow users to provide information collected by the ECMS, such as document type or purpose, which would be captured as structured metadata in the ECMS. That way we could put it in plain English, but also explain what it's being used for. If we're going to say collect in the ECMS at the site, get rid of then collected by the ECMS in the prior section where it says allow users to provide information, get rid of collected by the ECMS. See if that works. So these tools should allow users to provide information such as document type or purpose, which would be captured or collected as structured metadata in the ECMS. Because Dan, I completely agree with you. That was one of the things we allow people to call their documents anything they want to call it, but half the time it's gibberish. It's just some number they assign in their own document processing system or whatever. Or I can't tell you how many documents would come in saying letter to executive secretary, and that was the name of the document. And so we created our own document types, document subtypes that were standardized, that are captured during the e-filing process, so that when it comes in, we know what it is, regardless of what they decided to name that document, because that could be completely nonsensical. But that allows us to get that metadata, if you will, in a way that makes sense to us.
I like that revision. The one thing that I do think is I would still like to allow for is it's not necessarily the user that has to enter this metadata. Date, for instance, is a good instance, right? You should be capturing the date in which on which something is filed, because that allows you to kind of construct the chronology of a case. And so maybe these tools should allow users to provide, or the system to I don't want to use capture again, the system to record information such as document type, purpose, or date, which would be stored as structured metadata in the ECMS.
Yes,
Can I
you're right. We don't need to use capture the second time. We could just say collected or stored as structured metadata.
Can I suggest adding after allow users to provide or the system to record information about their submission? I mean, obviously it's in context here, but it's a little open-ended to just provide information.
And if we get rid of capture later, we can actually use that earlier, right? So allow users to provide or the system to capture information about their submission, such as document type, purpose, or date, which would be stored as structured metadata in the ECMS.
I love that. What about this last clause? So long as it would not be confusing or burdensome. Does that still fit?
I think so. Because if you are going to be asking the users to provide information by like selecting an option or filling something in or whatever, you obviously don't want that to be confusing. And I'm sorry, Annika, you had your hand up. I will stop talking.
Go ahead.
No, that's okay, because my question was about the first sentence. So if you're still talking about the second, I'll hold.
Thank you for revising it to users, Matt. Anything further, and then we could move back to that first sentence. I think this is really good. This is, I it's very helpful to understand exactly what this meant. Being an old dinosaur. Okay, let's go to the first sentence. Go ahead.
So my question is, in the first sentence, we talk about web-based tools to submit documents into the ECMS. But in the first recommendation, we've already talked about online processes that work well with your ECMS and the self-help portal. So what is the difference between a web-based tool that they can, file into the ECMS and the self-help portal that presumably talks to the ECMS?
Matt, we need you.
That is probably what's the word I'm looking for? Casualty of some restructuring here. Originally, like the report, we had e-filing first and then portals as a subsequent matter because they're more complex. But in thinking about it, a lot of times the portal is just an e-filing system. And so when we redesigned it this way, or when we restructured the recommendation this way, that's what came to be. We might be able to, in some way, more elegantly refer back to the self-help portals or the first recommendation if we wanted to, if we are troubled by this language. But basically, it's trying to differentiate itself from the email filing or the SFT.
I gotcha. Okay, because I think that there might be reasons why you want a self-help portal that talks to the ECMS, but you don't want people filing directly into the ECMS. And like from a security perspective, so I wasn't sure whether we were in number 8 trying to encourage some greater degree of integration than we were in the earlier part of the recommendation. But I think we need the metadata no matter what. I mean, I think the portals, no matter how you get the information to the agency, it makes sense to be able to capture and record whatever information would be helpful within the ECMS that it speaks to.
Well, I think we could probably committee on style the first sentence to make it consistent with the earlier recommendation without too much difficulty, unless people want to discuss now.
Roxanne, did you have a thought on this?
Yeah, Annika, would it help if we just got rid of the words web-based and just said develop tools that can use to submit documents directly into the ECMS? Because we have expanded from e-filing to create tools, internal tools that allows us to directly put documents into our ECMS in different ways. Just they're constantly evolving things so that we can make it easier and easier and easier to get documents, internal or external, into the system. And so maybe it does make sense to get rid of that phrase.
Yeah, and I'm not enough of a techie to know. I mean, I think for our agency, we have a web-based e-filing portal that does speak, very closely. They're probably not exactly the same, but they work together. It's like an overarching system, and I think that's what we want to make sure agencies do, but there might be all these sort of intricacies about how they do it. And I just don't know that we want to weigh in particular about how that is accomplished technologically.
Roxanne.
Yes, Annika, along those lines, our IT folks like to say, tell us what you need done, not how to do it, because they'll figure that out.
Agreed.
Okay, great. Well, Matt, I know you'll take another look through this. We want to make sure we're referring to things consistently, but I think we're on track. Anything further on 8?
Just
Really-
a small simplification. I would
Yes.
just get rid of to do so at the end of the last sentence. I don't think it's necessary.
Good. Thank you. Okay, let's move to 9. So this is about coordinating the agency system with an outside system? Am I reading that right now?
Correct.
Any concerns, suggestions, comments? Roxanne?
Not to unnecessarily add more wishy-washy language, but could we say agencies with an ECMS should consider developing? I know it's not a big change, but I know it would work in some scenarios, but it might not work in others. My husband was the CIO at the EEOC, and they just recently rolled out a new ECMS that does link with the ECMSs of all of their state partners so that there can be that internal transfer of data. But in hearing him talk about it, I don't even know how or why we would ever want to do that as our agency, but you know, what works for one might not work for another, but it's worth thinking about.
You did read my mind on that. I was thinking this might be a spot for us to consider. Kent?
Maybe this is implicit, but I think I would add and securely after to directly and securely transfer data. I know this is often an issue when we're taking one platform's data and moving it to a different platform. I'm going through this right now with our university system, and we're trying to find a way to do so. So I'll make that suggestion.
I like it. I like it. Anything else on this one? Okay, 10. Forms, templates. On the website. Russell?
Sorry, on 10, just a small point, 10B, you're
Mhm.
missing a B.
Oh, at the beginning, be based?
Yeah. That's the technical point. I also think in that same phrase, B, little small b, I would move the only after answer, because that's the only thing it applies to. Requiring users to answer only questions rather than only requiring.
No, I think it would be after answer, right? Is
Correct.
that what you said? Yeah.
That's what I think.
Always moving those only later in the sentence works.
Yes. Jack has given it its stamp of approval, so we're good. We got to keep that in mind for other stuff. I'm going to remember that one, Jack. Okay. Kent?
Maybe I'm misreading it. Should it be requiring users? Form should be based on pre-populated data and previous responses, requiring users to answer only questions that are relevant to them, or and require. I think it's the
think
price.
Requiring is good. Okay. Anything else on 10? We just have A and B. So, okay. 11? This is the e-signing issue that I think I recall we discussed at the council meeting we had, Matt, right?
Correct.
And not to put her on the spot, Roxanne, did you have experience with this? Was it Roxanne?
Well,
The e-signing issue?
Matt did ask us if we had any good use of electronic signatures, and unfortunately, we don't have we haven't gotten to the point where we're super happy with what we're doing for electronic signatures.
I was interested in the discussion about the email transmitting the document, which obviously if you're not emailing it, but you're submitting it through the ECMS, then But the idea that that somehow validates it or authenticates it. Any thoughts on this one? I mean, these are examples of what an agency can accept, right? Possible ways to deal with this e-signing issue. No reaction. Okay. It's perfectly written, Matt. Well, there's Russell.
Well, no, not to the substance, just in form. The items B, C, D, and E are objects. A is an action. I think you want to say a form or document submitted through an agency's rather than submitting.
Excellent.
I also
Well,
don't think you
close.
need the following in the above, but that's a different matter.
Excellent. Great catch. And just to make clear, these were all examples of what agencies have accepted or are currently accepting.
Correct.
Okay. As opposed to a wishful thinking, this is what you could do, should do. These are actually concrete examples of what agencies are doing. Okay, great. 12. Oh, Kent, yeah.
This is minor. I would just move the only, when it says agency should only, to if, only if there is a need to do so.
This is on 12, right?
Yes, so agency should review electronically filed documents for associating them with a case file only if there is a need to do so.
Following the rule we just learned. Great. Great, great, great. Any other concerns on 12? Roxanne.
I'm not sure what the purpose of 12 is.
Okay.
So they're saying that agencies shouldn't be doing these documents before they're associated with a case file unless there's some real reason to do so.
That's correct.
Because we review every document before we accept it. So I'm not sure. We have to do that. So we know that document is what it is, that it comports with our rules, that it's something that is supposed to be filed at that point in the game, that it's of a sufficient length or the appropriate length, or we have all sorts of reasons why we look at all the documents before we accept them. So I was just wondering what the purposes of telling agencies not to do that.
Matt?
It's mostly for efficiency. If an agency feels that they need to do that before making the document part of the case file, then I think for quality assurance purposes was intended to cover what you're talking about, making sure that the document is what it purports to be, et cetera, et cetera. But it was supposed to capture sort of scenarios such as large amounts of medical evidence being filed in a VA that might take the staff a long time to review, but the representative should be able to see immediately, that sort of thing.
Then for quality assurance purposes, I didn't take that to mean that. So maybe we could, instead of saying that phrase, we could say meets agency, comports with agency's rules or something along those lines.
Yeah, I almost had the thought that we would want to say the opposite, that they should review them, particularly when. Jack.
I was thinking the exact same thing as you, Nadine, because I don't know how an agency would know, for example, if a document is disclosing legally protected or other sensitive information unless they reviewed it. So it seems to me that agencies should review electronically documents if there is a need to do so. And because it may be that in some cases, there's like no chance that there's going to be legally protected or sensitive information. Therefore, agency doesn't need to bother doing it. Whereas in other contexts, it may be common. So, because otherwise, I'm looking at the whole sentence. I don't know exactly, how would you know if one of the reasons for reviewing it existed unless you had reviewed it? Unless I'm missing something, which I could obviously be.
Yeah, that was sort of the question I was coming at it from, because we take the opposite approach, which is everything has to be at least minimally reviewed to make sure that it's something that should be filed, that meets our rules, that it's not supposed to have been filed somewhere else, because that happens. We have to look at everything before we accept it. Oh, it doesn't go into the case file until we click a button saying we accept it.
So would you delete if there is a need to do so because there's always a need to do so?
I think you can say if there's a need to do so, because I can't
Okay.
speak for every agency. There very well may be many agencies that don't have a need to do so because they know with confidence that when these particular filers are filing things, it's what they need and it can just go straight into a case file. But I do like taking out the only, because then we're saying the opposite, which is you should review them if there's a need to do so, for example, and then lists all the reasons why there would be a need to do so.
Anything further, Jack?
Would this be a place to use the should consider formulation to make it clear that basically we're suggesting that they be left up to the agency to figure out whether they're generally going to have a need to do this or not? Should consider reviewing electronically filed documents, and then take out if there is a need to do so, for example, to ensure non-disclosure, that sort of thing.
That works.
Do we
But-
need the before then, the before clause?
Yeah, that I don't understand. So I'd like to hear from Matt on that. I don't understand the business about associating with the case file or not, and maybe once you associate it with the case file, then everyone with access to that file is gonna be able to get to it, and that's the issue. So
Right.
Matt, if you think that needs to be in there, I don't have any reason to say no to that.
I think it's Roxanne's point that you accept the document, right? So you review
Yeah.
it before you accept it.
Yeah, although quite frankly, even the rejected documents are still associated with the case file. They're just in there as a rejected document. They come in automatically into a particular case file. Whether or not we accept it or not is a different thing, but then we can always go back to that case and see, oh yeah, we had a few documents that came in that we rejected. We'll always know
Right.
that.
Sorry, Matt, you should speak to this.
Yeah, so I think the idea behind it was that we rely upon users to submit data in an appropriate, or submit filings in an appropriate way in the appropriate place. And we have an earlier recommendation that requires users to signal if they're filing something sensitive or in camera that needs review ahead of time. So there's implicit in this, the way it was originally written, is some trust that the users are operating it appropriately. And so everything should be as automated and require as little work on the agency side, as little burden on the agency side as possible, unless certain circumstances apply that might make it something they should consider doing. That was sort of the idea.
That's helpful. Thank you. Roxanne.
Yes, Matt, zero trust. That is what we're functioning from. We're constantly dealing with misfiled things.
And
Well, are we-
if an agency is dealing with a lot of filings with a lot of sensitive information, personally identifiable information, it may be appropriate to review everything
Yeah.
before associating with the case file. But in other cases, maybe not.
Yeah, and Matt, I totally appreciate that you're trying to get at some efficiencies here. I mean, we do happen to, in our e-filing system, ask people when every time someone's e-filing something, we ask them to check a box if the filing contains sensitive or protected information, so that it flags it for us before it comes in. And that's our way of not having to carefully read every document that comes in, because we expect people to self-identify on for that sort of thing, because that would otherwise you'd have to read the whole document every
Yeah.
time something was filed. And that's just not feasible. But we still have to look at all the documents to make sure it is something appropriate to be filed and went to the right place.
Right. Reflexively reviewing everything because an agency feels like they have to takes a lot of time and resources that could be applied elsewhere. Basically, this recommendation is trying to get to the idea of determining a list of criteria whether you need to review something for a particular business reason. And if not, then it shouldn't necessarily be reviewed before it's available to all parties. And if so, then if there's a particular business reason, then they should tailor their process to that. But in a lot of cases, maybe adverse adjudications are a good example where you're not only filing it with a case file, but you're also serving it on all the other parties. They already have it. If they've misfiled something in doing that, then that's no different than if you were doing it in a non-electronic system.
Jack?
How about agencies should consider whether to review some or all electronically filed documents, for example, to ensure non-disclosure and so on. That sounds like what you're trying to get at, Matt, if I'm hearing you correctly, is each agency should evaluate whether they should be doing this as a matter of course or not. And I think that may be. Does that capture that better?
I think that works. Any reactions? Matt, how do you feel about that?
It looks pretty good to me.
Okay. Anything else on 12? All right, before we move on, why don't we take a very quick break before we get into the next section? Thank you, Dan. I see you have to take off. Appreciate your input.
Thanks, Dan.
Let's take like 5 minutes if we can make it quick and get back. Thanks, Chris. And then we'll start with 13, lucky 13.
Thanks,
See you
Becky.
in 5. Thank you. Are we ready, Matt?
So cameras are off.
Give it a minute or two.
I didn't actually go anywhere. I just turned my camera off for.
Great.
You know, Nadine, I am very impressed by the technical ability of everybody here to understand and figure this out.
Completely agree.
You know,
All right.
I think part of that is the willingness to say, I don't understand what this means.
All right, I think we have a quorum.
Great. All right, let's start with 13. We're on electronic service. And 13 is pretty basic to me. Is there any thoughts? I guess 13 or 14. So one is, being able to provide service electronically. And then 14 is about if you don't have any CMS, how are you going to do that? Any thoughts? I wondered if, Kent, go ahead.
This is similar to an earlier comment I made in 13, since it says agencies should allow, but doesn't say that they should require parties. Do we need the accept clause?
Roxanne.
Kent, I think maybe we do. And the reason I say that is because even before we required e-filing, we allowed parties to serve other parties by email, as opposed to having to mail hard copies all to everyone. And so I think that if you are just allowing parties to serve documents, say by email, you probably still need that exception, because I think there were still times where, there weren't, sometimes people didn't have the ability to do that. But that would be my take on it. Why, even though it does say the word should, and normally you shouldn't need an exception to the word should, I think here maybe it works. Does that make sense?
Oh, sorry. I was just going to say, to your point, maybe it's useful because of who is the acting party and who's the object. Because if the first clause is should allow parties to serve, they're doing the serving, then maybe acceptance comes from the party receiving it, has good cause not to receive it. Is that similar to what you were saying? Okay. Point taken.
Jack.
Yeah, I'm a little confused about what looks like redundancy between the 13 and 14. Because 13 seems to apply to any agency, and then 14 is about, and it would seem like emailing is a form of electronic service. So I'm having a little trouble exactly grasping why those are two totally separate sentences.
Matt, do you have any thoughts here?
Yeah, I think perhaps 13 could be improved a little bit by referring to through the filing system, because I think we're assuming, because we say earlier agencies should develop these web tools to allow for online filing, that they should also provide service as well. And then 14 is saying if you don't have any CMS, then you should still allow for electronic filing through through email or another electronic format. I guess we should put in SFTP.
I mean, so could it be combined into one sentence? Either through an eCMS or by email? Or by email? By email?
And then you would still need the in addition.
Well, then I think I would, I think you would. Yeah, something, yeah. You could all, and I think then you get rid of 14, you just have 13. And then, but do you need the sentence about notifying them when, you know, I mean, it seems to me that what you're saying is that when a document is directly submitted to a docket or something, whatever it is, that service is basically to notify someone that there's a new docket on the file server, right? That's the equivalent of service. You're giving him, basically there's a notice of service without the actual document attached. You know, I mean, thinking about it as an old fashioned paper lawyer. So something maybe to capture that idea. That's what you're trying to say, right, Matt?
Correct.
So, you know, something, maybe another sentence in 13 that has that thought. You know, when agencies allow parties to submit documents using a file service FTP, is it the agency or the party that notifies them if there's a new document available?
Yeah, I am actually conversing with Jeremy because I think we have another recommendation that gets to that point in here. Then we might be able to combine them or make them consistent. But I wasn't able to bring it. I don't want to, leave this screen and go looking for it at the moment. But
you see what I'm saying? Maybe you have a sentence about, notifying people when a new document becomes available. You know, when a document is submitted directly to an agency's portal or something, then the parties entitled to service should be notified of the new document's availability or something like that.
Right. And
I think
that just brings in automation to the process.
Yeah.
But I think that's captured in that in addition line.
Yeah, something like that.
That's struck right now.
I can't, I don't know enough about the technology to know whether that's the right way of expressing what I'm trying to say, but I think that's what you're talking about there.
No, the in addition was to make this one consistent with electronic filing by email up above, where it was you could also use an FTP, an SFTP, or a file hosting service. It wasn't trying to that sentence wasn't trying to capture automated service.
So I'm not sure why it's in that paragraph. It was not about service. I thought these were about, this is the whole section about service.
Roxanne?
Yeah, and I was just going to say, I don't think we need that in addition language now that you've combined everything together, because the whole premise of this is that this is service of documents on the other parties. So it's presumed that these ways you're listing somehow gets those documents to the other parties. So I don't think you have to then also say, and the people will be notified that the new documents are available. Point is, this is service, ways that service can be done electronically.
I guess I read it as the concern being that if you just drop a document in a Dropbox, nobody knows it's there, right? Unless somebody notifies the other party that it's there.
It's a good point.
An email is going to somebody. The web portal presumably is going to be seen by somebody, but unless you separately email or notify a party that I've dropped something, or the agency, I've dropped something in this Dropbox, no one knows it's there. Go ahead, Roxanne.
So if the idea is that we're talking about service on the other parties, you're absolutely right. The other parties need to know about it. And so maybe at the beginning of that sentence, which I can no longer see, maybe we say, agencies should facilitate service of documents on parties electronically, either through, and then, or it's something where it's basically getting across that agencies are facilitating this service electronically, and here's a number of ways in which they're doing it. Because I agree, there has to be some notification to the other parties, whether it's they have some sort of subscription service that provides them with an automatic email when a document gets uploaded or something. But the concept of service to me is affirmative notification.
Are we combining these then? I guess, is that the idea here, Matt?
Yeah, I was basically suggesting keeping 14 roughly the way it is, but then adding a sentence before it for agencies with an electronic case management system that would provide automatic notification. Also, the former recommendation 18, current recommendation 17 talks about automated notices generally, and would include when a document has been filed, which also sort of encompasses this idea of automated notification or service.
So this is consistent with that language.
We'll want to double check to make sure, but
Okay. Jack.
Yeah, I don't think facilitate is the right word, because the question is, are they allowed to do it that way? I mean, am I, you know, that we're basically saying that's sufficient service. I mean, you know, and we've already, isn't there recommendations already that say that, you know, they ought to be designed to allow this kind of thing to happen? We're really, my understanding is this part is about, like, here's what you legally, here's how people can legally serve each other. Am I right about that, Matt?
I'm not quite certain I follow.
In other words, facilitate seems almost like another thing about setting up the technology. Whereas what I think this part is about what constitutes proper service.
How do you accomplish service with an electronic system?
Right, that's correct.
So it should be allow, I think, instead of facilitate. I think.
See, I think we're kind of right back to where we started, which
Yeah.
is allow parties to serve documents electronically.
See, I think that the point was the difference between 13 and 14 was about the automatic. Okay, so I think this, having the word automatic in there basically eliminates the problem that was puzzling me, which is these seem to be really redundant.
Now, if we, when we take a look at recommendation 17 or 18, or maybe we could take a look at it now and see whether perhaps we'd prefer to keep the one on service just saying it would be allowed electronically, and then use 17 to capture the idea of automation, so that even if you don't automate service for whatever reason, that you would still be allowed to do it. You would still allow for it to be done through the web portal or the or by email.
Yeah, I guess I read 17 as kind of like updates, not service. So when it's available to view doesn't mean service has been accomplished. I guess you wouldn't allow the party to see it if they hadn't been properly served. Jack, let's say, what if we think about the old paper way? How was service accomplished?
You sent the document to the person with a certificate of service, and if there had already been litigation started and they had been served, then you didn't have to get it served by a processor. You can mail it to them.
Right.
deliver it to them, as long as you certified that it was being done that way. Either you would say by hand delivery or by, deposit in US mail or something like that, or so I think that I don't see anything wrong with having a separate thing about how you do service. And I don't think it's overlaps with 17. I mean, I should say, I don't think it's redundant of 17. And I think it's probably important to say that, because an agency might not, even consider the notion that this electronic stuff, you would think they would in this day and age, but, that you don't have to go through any fancy rigmarole about service of process, or, you just use the normal way that you notify people about stuff. So I think it's good to have the subsection on electronic service separate from 17. But I'm starting to think that maybe you need 13 and 14, and so with it is, and 13 is about agencies with an ECMS, and 14 is about agencies without. We're saying if they don't have one, they should still allow by email. So the first sentence of 14 makes sense then, once you put with an ECMS and automatic, I think in the automatic or automated maybe is I don't know, something,
So if we restore 14, and presumably that covers agencies without, and then 13 is all about, now that we've added with, so we just need, with. Thank you, Matt.
ECMS, what happened? Something weird.
He's getting it. We'll get there with an
Okay.
EC. And we could get rid of the either, yeah. Okay. All right. Mm-hmm.
So maybe the first sentence should be the accepted instances when electronic service, because that applies to both 13 and 14, right? The idea
Accept.
that we're, so I think maybe first thing is agencies should allow electronic service, period. And then agencies with an ECMS allow electronic service, and that should be 13. Then maybe 14 is agencies with an ECMS, and 15 is agencies without an ECMS. And the part about agency electronic service, except in instances where electronic service is impossible or impractical, or a party has good cause for needing alternative means of delivery, that goes in 13.
Yeah. So we just unpacked it a little here. Yeah.
Yeah. And then 14 is law powers documents. And then now I'm just not understanding why you need the second sentence of 15, or whether that's redundant of 14 now with the 14.
It's just a different mechanism. Matt, you can probably speak to this better than I can, but so you have the web portal for an ECMS, or you're just doing email, or even further down the list, you're using this Dropbox.
Right. It's to be consistent with the electronic filing by email that we had above.
And that's only for agencies that don't have an ECMS. Or maybe not. I don't know. I guess it's not.
Or we could just delete all of this if we don't think it's needed.
As totally uneducated about how the technology is working and what people are doing, I have no idea whether it's needed or not. Is it a separate way of doing this?
Right. So
Jeremy.
the reason why they use these, and I'll let Jeremy speak in a second, but sorry to butt in, but the reason why they do these three things is because sometimes email systems have file size limits.
Nice. Mm-hmm.
And so if you have a particularly large file, then you might need to put it in something like this. That's what agencies who use these systems do. The other one is if they're filing something that contains secure information or private information that they don't necessarily trust an email system, which works with a third-party company to have, then they'll set up a system like this as well to protect privacy. Sorry, Jeremy.
No, that's fine. You got that. I was going to say, just think of file hosting system or SFTP as Dropbox, SharePoint. Those are all brand names, so we try not to use those in the recommendation. But you can think of those, and some agencies, as I understand from Matt, do use that instead of or in addition to email for these purposes.
So I think we need that line because it covers the universe, right? We've got ECMS, web portal, email, or some agencies will use this. I know we don't want to say Dropbox because that's a brand name, but.
Yeah, and part of the benefit of Dropbox is you can then automate, if I upload something to a Dropbox, somebody else has access to the Dropbox, get an automatic notice. So it kind of functions like what we've described in 14, whereas email obviously doesn't function that way. That's why 15 was structured as 2 sentences, but maybe there's a better way of saying that.
What if we just said agencies that allow parties and take out the in addition or as an alternative? I mean, just to cover that possibility that. So it would just be it's still a new sentence, yeah, but it would just say agencies that allow parties.
Better.
I don't know. Anything else on this? I think it's helpful to unpack all of it. I guess the only other thing on this, just to go back to that last line. So we're saying that agencies should notify the other parties when those documents are available. So are we saying that that's service? Or is it just that they've served it by putting it in the Dropbox and it's just a notification that it's there? Does that make sense, Matt?
It does. I mean, I think Jack could probably speak to this better than I can, but I would say the whole purpose of service is to provide or to guarantee or authenticate that the other party has a copy of the documents. Because we don't want to be sending things around willy-nilly, because it's more efficient to just keep it in this Dropbox, then the notification, I would say, should be treated as service.
Okay. Jack, you have further thoughts?
Yeah, I would say I would change that second sentence to agencies that allow parties to submit documents using a file hosting service or FTP should ensure that all parties are notified when new documents become available. Because they might not be doing the notification, it might be automatic in the case of a Dropbox. They just got to make sure they've set it up that way. So it's basically mimicking what I'm understanding is an ECMS system. Does that seem right?
Yeah, I think so. Okay, great.
Yep.
Yeah, go ahead.
Oh, I was going to say we could also do should affect service by providing automated notice, but I'm thinking since we haven't used affect service earlier, I don't know that we want to introduce it in the last sentence of the topics on service. I think it's probably cleaner this way.
I like it. Okay. Let's move on. This is our sensitive documents part, which I think is really important to have. Is Roxanne still? I mean, I really do think this is just making sure that parties are identifying things and redacting when we want them to before they submit the document for filing. Any thoughts on this? It's just basically allowing the party with the sensitive information to do the redacting themselves.
I think it's stating more which party, whether the agency or the party themselves, bears the burden of making that decision or taking on that responsibility. And making it clear to everyone who it is.
I think there's always an advantage to letting party do it, and then the agency reviews it before anything's released, but. Okay, 17, fees. I would know nothing about this. Filing fees. Where are these agencies that collect filing fees? I think this one's great. I've got nothing. Anybody? Got a quiet bunch as we wind down. Scheduling notifications and reminders. So 18, do we have a similar situation as we did with service? So 18 is all agencies, regardless of whether you have an ECMS. And then 19 is specific to an ECMS agency. Matt, do you want to speak a little bit about what the thoughts are here?
Sure. Agent 18 is something much more simpler to implement. It's sort of like what you might do to make a reservation at a restaurant, so you can schedule any kind of interaction that you might have with the agency. So for example, Social Security, you file an application electronically. They're then required to have an interview with you. You would be able to use a tool through their web portal that would allow you to schedule that at a time that's convenient for you. 19 is more about the case management system. So when you're doing electronic filing or other things that the agency is collecting structured metadata on, such as when a conference is scheduled, when an appointment is taking place, or a case status changes, maybe a decision is issued in your case, anything that would require a really sophisticated database on the agency side would apply in 19.
So 18, is it contemplated that this would be available on a website or a portal?
Right. If an
Okay.
agency has a portal, then it could be through the portal, but even if they don't, you could attach it as a widget on your web page if you wanted to. It's fairly
Okay.
an over the counter purchase.
Okay. Should we specify that there? Like what? Again, I'm being a dinosaur, I guess, but kind of where is this tool? How do they access it? How do they use it? Allowing them to use it is one thing. Providing it to them, I mean, I'm providing access to. Jack?
I was going to say something very similar to what you're saying. First of all, I think it should say something like the word online ought to be there at some point, so that it's what, because an appointment book, I suppose, is a scheduling tool. Call someone on the phone and make an appointment is a scheduling tool. So an online, but then allowing parties to use it almost sounds like they're allowed to use it for their own appointments. I mean, agencies should provide an online scheduling tool to allow parties to schedule meetings, conferences, hearings, and that sort of thing. Is there a reason to have appointment booking and scheduling? Or is that redundant? I mean, but agencies should provide an online scheduling tool to help parties schedule meetings, right? Because you're talking about to help parties schedule meetings, conferences, hearings, and other appointments efficiently. Or for parties to, help is sort of a nod for parties to schedule meetings Does that capture the thought?
I think those are good.
Yep. So then 19, I know Roxanne had to step away. I wondered if this might be a spot for our should consider providing. I just don't know how complicated it is to set something like this up. Maybe it's not. I don't believe our system at my agency does some of this. You know, notifying, in reading this, it made me think of your doctors when you set up a doctor's appointment and then they call you a week or two in advance and let you know you have an upcoming appointment. And it's because they don't want to they don't want you to be a no-show and waste their time. But whether there's some thought to, you know, babysitting parties a little bit here and hand holding and, you know, hey, you have a brief due in 3 days. Represented parties and attorney, they know that. But anyway, I just wondered if it should be a should consider. It was something that crossed my mind. Any reaction to that? Jack?
Well, I mean, I just going to say that seems to me that we need to ask the question, you know, whether this is something that would be like part of the normal package of an eCMS or whether, you know. So, I mean, the way it's written, it's fine. Question is whether we need to add the consider. So maybe we need to just defer that to the next, we're going to have another meeting on this, right?
Yes. Roxanne?
I'm sorry, I had to step away for a second.
Not at all.
I would be in favor of the suggestion that add the word consider. Because some of these things I think would work for some agencies and others might not. Along the lines that Nadine was saying, maybe some agencies don't find it appropriate to hold parties' hands by telling them a filing deadline is approaching, but others might find that very helpful. So I think consider would be a good addition.
I will just quickly point out that the pilots in state courts that have done this, particularly automated notifications of appointments, has saw a significant decrease in their no-shows. So it may be something that even if agencies will only consider, that we at ACUS might want to recommend as a good policy. But on the other hand, no agency currently does these things some of them. There are automated notifications when a new document is submitted, no notice or order is available to view. And
Well,
status changes, but not D, E, or F, or C, D, or E, I don't think.
Is there a benefit then to pulling that apart in terms of what we would want them to do and what we would want them to consider doing? Roxanne?
Yeah, I would say if Matt, if you were hoping this to be more of a actual recommendation than just think about it sort of situation, maybe we take out consider, but we say should provide automatic notifications or reminders as appropriate, to just add as appropriate, because then agencies could decide, okay, which of these notifications are appropriate for our types of business model versus considering whether we want to do it at all. Would that help?
Well, I think from my perspective, I wrote the entire recommendation without using the word consider, and I leave it to the committee to decide when consider is appropriate.
It was something that I asked Matt to do, and everyone, in fact, we're gonna be a should agency, because I don't feel that necessarily requires them to do something just that we feel strongly about it. We've considered it, and we think they should do it. And then if the committee or the council or the plenary feels differently, then that's fine.
And at the end of the day, an agency isn't going to do something that doesn't even make sense for them. Like if we don't have appointments that are scheduled that need reminding, then of course we're not going to do it. But I think we can assume some level of common sense when people are reading it.
Jack, did you have another point?
Yeah, I'm not convinced that the words "as appropriate" belong there. I'm not sure if that means as feasible or as applicable or as necessary. I don't know. But the other thing is, this is a really tiny point, but maybe we want to put the stuff about meetings and conferences and filing deadlines up front. Like maybe A ought to be when a meeting, conference, hearing, or other appointment is scheduled, because that seems to be the biggest thing about this, right? I mean, that was your experience about, that it reduces no-shows. Important developments or, important, events and developments in their cases, such as when a meeting, conference is appointed, a filing deadline is approaching, an appointment is upcoming.
Important events or developments is good. I mean, they're not all developments, right? They're
important events or development, and important events about important events and developments. I would say and, not or. We want both. Does that make sense to be that worried about the order?
I think that order makes sense.
Did we miss one? Did we lose one? Oh, E and then F. Yeah.
F. Should it be the case status changes, not A?
That looks good.
Anything else on this one?
Yeah, just I don't know what people think about this, but in A, it says a meeting, conference, hearing, or other appointment is scheduled. Would it make sense to say is scheduled or upcoming? And then we could get rid of, where's the one? C, which is an appointment is upcoming. But I mean, that would put the onus on them notifying people, not just for upcoming appointments, but also about meetings, conferences, hearings, and other things. But how would people think about that?
I think that works. Anything further? Okay, let's move to 20. How are we doing on time? We got 15. Okay. This is about developing and improving. Did wonder if this should be moved up further to the top of the recommendation, but because it seems like the first step, right? The develop one.
Yes.
But I guess if you have one, you also want to find ways to improve it. So Any thoughts on 20 and 21? And 22? We have 3 here, right? Yeah. Nothing. Okay. Guidance, training, and outreach. So these are all great. I did have one question on these, and it was, I just can't remember if we've touched on this in other recommendations. I really should be able to remember, but Matt or Jeremy will help me. I'm thinking about documents and materials that may need to be translated and available to communities in different languages. I don't know if that's beyond the scope of this, if that's just something we don't really mention. But I know there are some considerations there that I know for our agency, we've done Spanish translations of a lot of our user guides, particularly our case management system, our e-filing system. And whether that's something to mention.
I can speak quickly to that. There was in an earlier draft of this recommendation some reference to that, as well as Section 508 compliance, because well, if you use a PDF for a form, that's built into the system, but if you design a web-based form on your own, maybe not, you would have to consider that. I believe we pulled those out because the recommendations ended up being something like, you should follow the law rather than necessarily a best practice. So, but happy to discuss putting them back in if people.
Yeah,
want.
I think the 508 stuff is obviously required. I'm not sure how. I think it's encouraged. I'd have to look at that closer, but the translation materials, but language access is an important part of outreach. Roxanne?
Would the language access aspect fit in the prior 3 paragraphs somewhere with the development of the system? I mean, if there was somewhere in here, like maybe in 20, toward the end, where it says you can continuously solicit feedback, but maybe it's also agencies that should also explore avenues for translation into other languages that would best serve their constituents or something like that. Maybe we put that in the development section.
Renee, I see your hand up.
I know I missed a lot of the meeting and I apologize, but I do have this issue, discussion of language makes me ask, are there provisions that you've already talked about other forms of accessibility? You know, for vision impaired people, that sort of thing?
Matthew said that they'd started to try to write a provision about saying it needs to be like 508 compliant, but then they realized they were essentially just saying we have to comply with the law.
With the law. Oh, I see what you're saying. That's what that comment was referring to.
Yeah.
I'm sorry. I just didn't
no, that's okay.
connect the dots. Okay. But I don't know. I mean, I understand that. And I guess the question is, maybe we should have a phrase somewhere that says, you know, accessible, including, you know, compliance with other legal obligations for, you know, activities like this or platforms like this or something like that, because I just sort of fear that if we put it out there without like mentioning it in some way, it'll be an issue that comes up. And I'm not sure people will be satisfied. Well, we'll assume that the agencies are going to apply with the law. I'm not, no offense to anyone.
Jack, and then we'll go to Roxanne.
Yeah, maybe this could be something to address in the preamble. You know, because again, I agree with the general ACUS practice of not saying, by the way, also comply with the law. But maybe, you know, in the preamble, you say something like agencies must be mindful of, you know, requirements and practice and best practices regarding language and accessibility for, you know, for people with, you know, whatever the proper way of saying is, with disabilities or with challenges or whatever. you know, that these have to all be designed in light of those things, but without putting anything in any specific recommendation, because the recommendations do contain numerous situations about how, like if electronic service isn't proper for a particular party or whatever, that they can use some other way. So that's kind of captures it. But I think explicitly saying follow the law is something it's a pretty good practice not to put it in there, but maybe in the preamble, something that captures that thought more specifically about language and disabilities.
Roxanne and then Kent.
I think that Nadine made a good point, which is that I don't know that it's clear how many languages need to be incorporated in complying with the law, whereas 508 is really more disability accessibility. So while we might not want to say comply with the law with 508, because that should be obvious, we might want to say something about, actively say something about languages, and maybe it would fit easily and pretty succinctly in 21, where it says when designing or working with a contractor to design their online processes, agencies should create systems that are legally compliant and can be translated into languages to promote accessibility by constituents, as well as can be, sorry, I'm just sort of dictating off the top of my head, and I'm not saying this is all that artfully phrased, but just if we could just fit something a little in here that says we need to think about translations too, and it's just going to get more and more down the road, and so maybe that's why it would fit into this paragraph where we're saying make sure your system can continue to meet the needs going forward.
Kent.
I like the idea of highlighting the specific point we're concerned about with overall general accessibility and language, but I think I still prefer Jack's option of putting it in the preamble, because I would want the same thing with the guidance, training, and outreach. And I feel like it would get a little repetitive doing it for both the development of it and then the guidance. I just make it more holistic, but I like the idea.
Good point. I hadn't thought about that aspect, which is it applies to a lot of different areas.
Yeah. Okay, let's think about that. From my own experience at our agency, I know we have a lot of Spanish speaking employers, employees that come before us. And so we made a concerted effort to post a lot of our user guides and materials in Spanish so that they can fully participate, right? And I think that's a goal of, the current administration as well. So just something to think about. Okay, so guidance, training, and outreach. I think that's our last section. I think we can squeeze it in. We've got a few minutes left. Anything further on the language here? Russell.
Just to repeat what I said earlier, that I have to make sure that 22, I guess it's 23 now, comport with whatever revisions were made to recommendation 5 back about requiring or allowing online filing. And I didn't say to do it here, but when it gets rewritten, just make a note that has to be consistent.
Consistent. Okay. Thank you. Anything further on this? Roxanne, I was curious about how when you have users who have difficulty using this system, do they have staff that they can access?
Yes, including me. No, basically anyone in my office. We have walked many a user through our e-filing system over the phone, and one time I actually walked a person through it all the way to the end, and then he said, well, I don't remember where I saved the document I want to upload. And I said, well, I'm sorry, I can't help you with that. But anyway, yeah, so we have staff, and we have in our e-filing terms and conditions, it says that we are available during normal business hours. And while you can e-file up until 11:59 p.m., be advised no one's going to be around to help you after, normal business hours.
Got it. Okay. I'm going to assume we're good to go then. We will have another meeting. May 4th. Do I have that right?
You do.
May the 4th be with you. Is that the whole? Yeah. Okay. So May 4th, 1 to 4. We will have preamble. And any suggestions from the committee on style and your expertise, Matt, to smooth out some of the things we've done?
Absolutely.
Yes. All right, great. And we are early. Any other, we've got 2 minutes. Nothing.
I think we should just pat ourselves on the back for being super efficient.
Yes. I like that idea.
Absolutely.
Small but mighty.
And I want to thank everyone and particularly praise Matt Bluth for the work he did on all of this. And I think you helped us improve it. And I'm terribly impressed with all the technical knowledge that I didn't realize we had here, technical expertise. So thanks for that. See you on the 4th. Thank you, Nadine.
Thank you very much. Take care.